incites a member of a Chinese armed force A to abandon the duties and abandon the allegiance to China, or B to organize, initiate, or participate in a mutiny, commits an offense and is liable on conviction on indictment to life imprisonment. Subclause 2 in this section, and then there is a definition of certain terms. Mutiny means an act done by two or more persons who are, or at least two of whom are, members of a Chinese armed force. And then A, to overthrow the lawful authority in a Chinese armed force or in an army or force of a government or organization of a foreign country that is acting in cooperation with a Chinese armed force, or B, to resist such lawful authority in such a manner as to substantially prejudice the operation efficiency of a Chinese armed force or of a part of an army or force of a government or organization of a foreign country that is acting in cooperation with a Chinese armed force. Questions? Mr. Kitson Yang. 17(1)(a). I have a question. I see in subsequent provisions the same description, to abandon the duties and abandon the allegiance to China. Can you explain about this expression? What if somebody incites the personnel to abandon the duties but not to abandon the allegiance to China? Then will it be caught by this provision? Can you explain how this is drafted? Do allow me, Chairman. Incitement of members of Chinese armed force to mutiny. This is a very serious offense. As you can see in the penalty clause, the maximum offense is, the maximum penalty is life imprisonment. So what is exactly is described here? If somebody abandons the duties and abandon the allegiance to China, then it is not as serious. The point is, if this happens, both happen at the same time, involving a member of a Chinese armed force, and this becomes something very serious, and this is reflected by the level of penalty. Next, Mr. Holden Chow. 17(1). A person who knowingly incites a member of a Chinese armed force to abandon the duties and abandon the allegiance to China. Knowingly, my question is on this term. What knowledge are you referring to? Inciting a member of a Chinese armed force to abandon the duties. Well, the intention is crystal clear. If you want to incite a member of a Chinese armed force, you come with a very clear intention. Then why is it that the person who must knowingly incite so and so? Because if you include the word knowledge, it means that the person must possess knowledge of a certain thing. Do you mean that by inciting this member of a Chinese armed force, you know that the effect is that this armed force will abandon the duties? Or what kind of knowledge are you referring to? Or is it something like this? You have knowledge that this is a member of a Chinese armed force and you continue to practice incitement, then and that if you have no knowledge that this person actually is a member of a Chinese armed force, then you won't be caught. I want you to explain what knowingly or knowledge here means. Yes. I'll try to take this question first. If need be, my colleagues can supplement. If we take a look at the English text, it will be clear. Knowingly incites, that's the term. This person knows what he's doing, regardless of the means. this person knows that the action is one of incitement. He is inciting a member of a Chinese armed force. We categorically provide the word knowingly so as to express the need for mens rea. DOJ, let me supplement. This term knowingly refers to this person having knowledge of who this person is being incited. That is a member of a Chinese armed force. And because for every Chinese citizen, there is a natural duty for them to pledge allegiance to China. If I incite this person to abandon the allegiance to China, without knowing that this is a member of a Chinese armed force, it doesn't constitute the offense. So we want to make sure that these elements are met. Well, that's exactly what I thought. Thank you. Mr. Tony Chair. Well, I think my question is similar to what Mr. Holden Chow just asked. I also want to know about this term knowingly. That means this person knows of the person's identity, and on this knowledge, you continue to incite this person. Anything else? No. Mr. Stanley Ng. I think I share the same concern of Mr. Holden Chow. Now we have a very clear answer, but I need to clarify a couple of things about mutiny. Why is it that the act should be done by two or more persons? What is the basis of prescribing two or more persons? Why can't one person practice mutiny? And then 2B, to resist such lawful authority, my understanding is the Chinese armed force as a lawful authority, because you put in the word such, and there could be different forms of authority or forces. And I'm not sure whether you should distinguish between lawful and unlawful authority. So why don't you just prescribe Chinese armed force instead of lawful authority? Let me take the first question. As for the second one, I didn't quite catch it. Perhaps I'll ask Mr. Ng to elaborate on it. On the first question on the definition of mutiny, I would invite members to refer to another piece of legislation. The definition does not exist in the Crimes Ordinance. During the consultation, the Hong Kong Bar Association has suggested providing a definition of mutiny. So for the Criminal Act in Australia, there is a similar explanation on mutiny. So this is modeled on the Australian provision. Now, if only one person who is a member of a Chinese armed force is involved, we should refer to 17(1)(b). That is an incitement offense. If you incite a member of a Chinese armed force to abandon the duties and abandon the allegiance to China, this already constitutes the offense of mutiny. Right, please repeat the second question. No, just to pick up on the last point, an act done by two or more persons. Well, you just answered that you made reference to an Australian act, but the act itself involves an incitement. Why is it that if the act is done by one person only, it does not constitute an offense? DOJ. Chairman, as I explained, if a member of a Chinese armed force is involved, that is committing the crime of insubordination, failing to obey orders from above, then this constitutes the act of abandoning duties and abandoning the allegiance to China. It is an incitement, and we believe that 17(1)(a) should suffice in handling this situation. SJ? Now, for mutiny, I think we need to consider the verb as well, to organize, initiate, or participate in a mutiny. So if you organize something, it involves more than one. If you initiate a mutiny, more than one. And if you participate in a mutiny, again, more than one person. So that's the concept of mutiny. If we focus on the act of one individual, then at least it's 17(1)(a). So let's make it clear. He will not be let off. It's just a matter of which provision applies.
Can I get to my second question? I want to repeat my second question. It's about mutiny in B. To resist such lawful authority. Such lawful authority. There are many antecedents for lawful authority without a clear definition. So the reader is left unclear. So why not just say a Chinese armed force in subclause B under 2? Thank you, Chairman. Lawful authority has to do with paragraph A. Paragraph A refers to two authorities: a lawful authority in a Chinese armed force, or or the force of a government or organization of a foreign country. So by such lawful authority, you're referring to what we see in paragraph A. Why not just spell out? Just say lawful authority in paragraph A. There is just one antecedent, paragraph A. There is no reference to any other lawful authority. So by saying such lawful authority, the phrasing there is clear enough. It refers to paragraph A. Moving on to clause 18. Assisting members of Chinese armed force to abandon duties or absent without leave. Subclause 1. A person commits an offense and is liable on conviction on indictment to imprisonment for 7 years if the person, knowing that a member of a Chinese armed force is about to abandon the duties or absent himself or herself without leave, assists a member in doing so. Subclause 2. A person commits an offense and is liable on conviction on indictment to imprisonment for 10 years if the person, knowing that a member of a Chinese armed force is about to abandon the duties or absent himself or herself without leave, colludes with an external force to assist the member in doing. Subclause 3. A person who, knowing that a member of a Chinese armed force has abandoned the duties or has absented himself or herself without leave, A. conceals the member, B. assists the member in concealing himself or herself, or A. conceals the member, B. assists the member in concealing himself or herself, or C. assists the member in escaping from lawful custody, commits an offense and is liable on conviction on indictment to imprisonment for 7 years. And subclause 4, a person who, knowing that a member of a Chinese armed force has abandoned the duties or has absented himself or herself without leave, colludes with an external force to A. conceal the member, B. assist the member in concealing himself or herself, or C. assist the member in escaping from lawful custody, commits an offense and is liable on conviction on indictment to imprisonment for 10 years. Questions, Mr. Kitson-Yang? Clause 18, subclause 1. Under treason, there's a requirement to disclose the commission of treason. So someone comes across the fact that someone else is trying to absent himself or herself without leave. Is there an offense for those who fail to disclose knowledge of this kind of offense? No, we target those assisting someone to abandon duties. So staying silent is fine. That's an offense only in the context of treason. Mr. Chen Xiuhong. I have a similar question. So someone knows that a member of a Chinese armed force will give up duties or go AWOL, there should be a duty to disclose the knowledge. Otherwise, there may be some form of assistance. I don't quite get the point from the S4S. There should be a duty. You know someone from an armed force, you know this member is about to abandon their duty or go AWOL. Who should a person with such knowledge report to? So staying silent will not constitute an offense. Can the government clarify this point? That's the legislative intent. It's about proportionality. In treason, we make it an offense to fail to disclose such knowledge because treason is a grave offense. But we have to strike a balance when other offenses are at play. Murder is important, for example, but we don't have an offense for the failure to disclose information about the knowledge of someone else about to commit murder. Next, Mr. Stanley Ng. Clause 18, subclause 3C. 3C. Assists the member in escaping from lawful custody. The penalty level here, is it lighter or heavier than the penalties for helping a prisoner escape? If the penalty is lighter, then the question is, why have a lighter sentence? If it's stiffer, then that only makes sense. As for S, we need to look up the information before giving a response. Any other questions? No. Ms. Carmen Khan. Thank you. Clause 18, bracket 1. It's about knowing. Clause 17, subclause 1, knowingly incite. Is there a difference in the extent? Is there a different shade of meaning at work? So difference between knowing under clause 18 and knowingly incite under clause 17. Who will take the question, please? I will take this question. Clause 17, the focus is on incitement. Clause 18, the focus is on assistance. There's a difference between incitement and assistance. So there are different penalties. For incitement, the penalty can be up to life imprisonment, but for assistance, the penalty will be 7 to 10 years in jail. Now, in English, they look similar. The phrases look similar, knowing, knowingly. I don't see any real difference. Wouldn't it make more sense to align the wording in drafting? Knowingly is in line with the language under the crimes ordinance. We can look at that again, but that's how I see it. I could be wrong, but I thought knowingly is actual knowledge. And knowing will cover ought to know, reasonable grounds for believing, etc. So is there a distinction in the state of knowledge? Knowledge refers to actual knowledge. So can you look at ways and whether we can align the wording? Now, constructive knowledge, reasonable grounds for belief. We spell that out separately in other ordinances. When the distinction matters between actual and constructive knowledge, in criminal law. So here, knowingly, they refer broadly to actual knowledge. So that clears up the question for Ms. Carmen Khan. Thank you for your guidance, Chairman. In Chinese, 明知 and the Chinese term for 知識, the wording is different, but in English, it's knowingly. So as the chairman suggested, let's consider whether we can align the wording and whether we can improve the phrasing. But it's worth putting on the record that knowing and knowingly are the same. Actual knowledge covers the cases of both 17 and 18. We're not saying that 17.1 is a more serious case. Now, Clause 17, Subclause 1, to abandon the duties and abandon the allegiance to China. Incitement to mutiny is a grave offense that carries life imprisonment. So we need two conditions to be there. Whereas assistance for someone to abandon duties, it's a different offense. We don't need an element for abandoning duties and abandoning allegiance. Any response? Now on the sentencing, 10 years for incitement to abandoning duties and allegiance. Ms. Carmen Khan is right on the point about having two elements. Now, let's look at the prison's ordinance. For helping a prisoner to escape custody, the maximum sentence is 2 years. But here, the maximum sentence is 7 years. Any response from other officials? No? Mr. Tony Ted speaking for the second round. The first round, actually. I want to clarify a point, Clause 18, 3C and 4C. Escaping from lawful custody. What if it's bail? Is that custody? Or being on the wanted list, does that count as custody? Custody means it's a lawful form of detention. But when someone's on the wanted list, this may refer to someone hiding. Other questions? Chairman. So when someone's in hiding after escaping, so what are we looking at? Escaping means it's escaping from lawful custody. While this person is in lawful custody, the person escapes. If the person is on bail or on the surety on a bond, then this person is in hiding. The hiding can take place in different places. So that's for hiding. All clear. Thank you. No other questions. Let's move on to Clause 19. Inciting disaffection of public officers. Subclause 1, a person commits an offense and is liable on conviction or indictment to imprisonment for 7 years if the person knowingly incites a public officer to abandon upholding the basic law and abandon the allegiance to the HKSAR. Subclause 2, a person commits an offense and is liable on conviction on indictment to imprisonment for 10 years if the person colludes with an external force to knowingly incite a public officer to abandon upholding the basic law and abandon the allegiance to the HKSAR. In this section, public officer means A person holding an office of emolument under the government, whether such of office be permanent or temporary. B, any of the following persons, if the person is not a person mentioned in paragraph A. 1, a principal official of the government appointed in accordance with the basic law. 2, the monitoring authority appointed under section 5A of the exchange fund operation, or a person appointed under that ordinance. 3, the chairman of the Public Service Commission. 4. A staff member of the Independent Commission Against Corruption. 5. The Ombudsman or a person appointed under the Ombudsman Ordinance. 6. The Privacy Commissioner for Personal Data or a person employed or engaged by the Commissioner under the Personal Data Privacy Ordinance. 7. The chairperson or a member of the Equal Opportunities Commission or a person employed or engaged by the Commission under the Sex Discrimination Ordinance. 8. A judicial officer or staff member of the judiciary. C. A member of the Executive Council. D. A member of the Legislative Council. E. A member of a district council. Or F. A member of the election committee as defined by the Chief Executive Election Ordinance. That's all from me, Chairman. Questions? Dr. Kennedy Wong. Thank you. There are different kinds of public officers. I want to clarify a point. 3B2. Does that cover the CEO or chairman of the Securities and Futures Commission? In finance, the SFC is a key player. There are other public offices. There are public bodies, such as the Airport Authority. It's a major asset of the government. It's also a key piece of infrastructure. So can the government tell us the reasons for having some categories here but not others on the list? The DS, please. Just then, Dr. Kennedy Wong asked about the extent to which we set out the list. Now, on what's on the list, these are people who play a key role in the government, or like the Ombudsman, the Privacy Commissioner for Personal Data, and the EOC's chairperson. These three bodies have investigative powers. And during investigation, these people come across government information. When these people are subject to incitement that will affect government operation. We have also thought about whether to broaden the scope to enhance the protection. If we go very far, then for those people, and some of these people are not in a paid position, we're talking about abandoning allegiance to the HKSAR or the Basic Law. Let's think about this. Say a family member tells a person to abandon the job. So if we include those positions on the list, so there's a worry. Potential candidates for advisory bodies may hesitate. So we take this approach, as you see on the bill instead. We only include on the list people with a role that will directly affect government operation. So that's our thinking. Chairman, I mentioned the SFC in particular. The government's response from the DS said that some of these roles have investigative powers or prosecution powers. The same goes for the SFC. So why not the SFC? Chairman, the investigative powers of these three bodies mean they can access government information from departments. These roles have access to confidential government information. So when we look at the impact on government operation, it's appropriate to include just these three roles. And that's more important than including on the list other advisory bodies. That's why we have them here. Chairman, I also asked statutory bodies, Airport Authority, why not put that on the list? Chairman, it's the same principle. We consider whether the impact on the government would be serious if incitement were to occur. So the consequences of incitement for people in those roles are different from incitement of people in the roles on the list. But the airport authority and the SFC are not advisory bodies, they are statutory bodies. The airport authority and the SFC are in charge of their respective areas that are vitally important. But I guess that's fine. Mr. Gary Chen. Can I clarify a point? Some civil servants told me about their worries. They retire, they want to emigrate to a certain place, live overseas with another civil servant who will retire later. So a retiring civil servant asks another civil servant who will retire later to live abroad. They wonder whether that counts as inciting disaffection. I assure the civil servant, but they are not convinced. So can I take this opportunity to ask for a clarification? Now I turn to the question about the EOC. It covers the chairman, the chairperson, and the staff members. But why are we just including the chairperson of the Public Service Commission without covering the members? Why the discrepancy?
Thank you. On the first part, the incitement we are talking about is inciting abandonment of allegiance to the Hong Kong SAR and the upholding of the basic law. Now, retirement plan is a very personal thing. Career and life planning is very different from upholding the basic law and pledging allegiance to the Hong Kong SAR. Deputy Secretary, the chairman of the Public Service Commission is a position with emolument. It is different from other members of the PSC. Now, I think the first question is very important. The point is how we interpret the term abandoning the allegiance to the Hong Kong SAR and upholding the basic law. Now, some people may think that by giving up your positions in the government, you are abandoning your allegiance to the Hong Kong SAR. Now, I refer you to Section 3AA. There is a very detailed list listing out what actions constitute to the abandonment of upholding the basic law and allegiance to the Hong Kong SAR. For example, if you support the carving out of Hong Kong from China, and if you support Hong Kong independence, that would count as an act of abandoning the allegiance to the Hong Kong SAR. So I refer you to the provision. By leaving the government, you don't have to worry. So please trust our explanation. Mrs. Regina Ip, Chairman, I share the same view with Dr. Kennedy Wong. The SFC or even the Hong Kong EX, these bodies have investigative powers. These are important financial bodies, so I am perplexed why they were left out and only the HKMA is here. I thank the Secretary for Justice for his explanation. For a electrical member or even a district council member, for any personal reason, say health reason, a friend advised me to give up my position in the electrical or the district council. Does that amount to inciting disaffection? Mr. Paul Lam has answered us. I also refer you to Cap 1. There is the positive and the negative list on what constitutes allegiance or abandonment. Now, if you advise a district council member to give birth and get the $20,000 newborn baby bonus, and you should leave the position, that doesn't amount to inciting disaffection. So the real question is why only HAMA is included. Allow me. We adopted a risk-based approach in drafting the law. We assess the risk that upon incitement of disaffection, whether the consequence would be significant. So we took a risk-based approach. It's now my turn. My first question relates to Dr. Kennedy Wong's question. A person holding an office of emolument under the government. Under the government, does that mean subvented schools, public bodies, advisory bodies, and so on? I think you have answered my question. But still, I have some concerns. The HAA and the SFC, these two bodies perform very important societal functions. One is a regulatory body, the other is the body managing our airports. So I'm quite surprised why they are being left out. But I know you have your own considerations. I think these two bodies are very important to the overall governance and operation of the government. So that's my comment. Second, why are the official members of the EAC are also covered under the term public officer? I mean, the member of the election committee. A member of the election committee has the right to vote for the chief executive. The risk pertaining to this position is high. That's why we are also including member of the election committee. Mr. Stanley Ng. Chairman, I agree with you. I also wonder why some statutory bodies were left out. Bodies like the hospital authority, it is also an important body. So that's just my view. Concerning the scope of coverage of the term public officer, point F, member of the election committee, besides chief executive election, the members of the election committee can also vote in Legislative Council members' election or even Hong Kong deputies to the NPC. On the district council level, we also have the 3 committee members. Shouldn't the members of the 3 committees be covered as well? Security Bureau. Mr. Stanley mentioned the 3 committees. Now it also boils down to the extent or significance of risk. Now the 3 committees, they are the fire safety committees, the crime committees, and area committees. So we think, considering the extent of the risk pertaining, it is suitable to leave them out. Ms. Carmen Kan. I share the same view. Me included, I'm the 5th member pointing the same. Dr. Kennedy Wong, Mr. Stanley Ng, Mrs. Regina Ip, you and myself have also raised these questions. Now, as a public officer, they are potential targets of incitements of disaffection. So we have to assess the risk of being incited to disaffection and also the risk to national security. HAMA, SFC, chairman of the SFC, chairman of the HAA, and also the chairman of the hospital authority, the chief executive. Well, let's not forget, in the part of state secrets, the same definition for public officer applies. It seems the main focus now is whether the office comes with emoluments. As the Secretary mentioned, the Chairman of the Public Service Commission is included because it is an office of emoluments. Now, we also have the Chairperson or member of the Equal Opportunities Commission, the Privacy Commissioner for Personal Data, and the Ombudsman. It seems that the criteria is emolument. Now, the Chairman of the SFC, the Chief Executive of the Chairperson of the HKAA, it seems that these are not officers of emolument. But you have to look at the risk to national security when these people are being incited. The line of work is closely related to state secrets. So maybe we should add a subclause G that, depending on the circumstances, the chief executive in council may amend the definition of public officer. The major concern is not whether it is an office with emoluments. It is about the significance to the operation of the government, the society, and whether public power is being exercised. That should be the most important concern. Please answer Ms. Carmen Khan's question. I agree with Ms. Carmen Khan. Emoluments or not is not the major concern. It's about the risks to our overall public safety. I also agree with Ms. Carmen Khan that where necessary, we can amend the definition of public officer through subsidiary legislation. With developments in society, the risks are ever-changing as well. So the definition, the list of public officer is subject to changes. Allow me to state my opinion. In selecting and appointing these important public officers, as you said, the SFC, the HKAA, these are bodies affecting the daily operation of society. Even if they fall outside the definition of public officer, you should consider them as well. Now, in English, it says whether they are upholding the basic law and whether they pledge allegiance to the HKSAR. These are important considerations. So these should also be the factors you consider. Secretary, I agree. You mentioned amending the term by way of subsidiary legislation. Actually, you should put the definition of public officer on a schedule. That would make it easier for you to amend. If you set out the definition by way of a schedule or an annex, it would be easier for you to amend it. We will study it after the meeting. Mr. Jeffrey Lam. Thank you, Chairman. First of all, I agree with the Chairman and Ms. Carmen Khan on the definition of public officer. We should look beyond whether the office comes with an emolument. My observation is this. On the list, ICAC, Ombudsman, they serve a particular function. They have investigative powers. Same goes for SFC, not so much for the Airports Authority. So is this also a criteria? As I said, we consider a range of factors, whether it comes with an emolument, the extent of public power, whether the position comes with access to government's secrets, and also the significance or consequences of such people abandoning upholding the basic law and allegiance to the HKSAR, as well as the impacts on public safety. I mentioned investigative powers because it would have an impact on other departments and also the private sector. Some are even empowered with prosecutorial power. So that's my suggestion. Next, Ms. Carmen Kan, second round, 3 minutes. Chair, a very brief question. What about the Director of Audit? Does Director of Audit count? Does that office fall under Part A? Yes, Director of Audit is a principal official, so the position falls within the definition of A. Let's move on. Clause 20. Thank you, Chairman. Inciting disaffection of personnel of offices of central authorities in Hong Kong. 1. A person commits an offence and is liable on conviction or indictment to imprisonment for 7 years if the person knowingly incites any of the personnel of any of the following offices of the central authorities in Hong Kong to abandon the duties and abandon the allegiance to China. A. The Liaison Office of the Central People's Government in the Hong Kong SAR. B. The Office for Safeguarding National Security of the Central People's Government in the Hong Kong SAR. C. The Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR. Subclause 2. A person commits an offence and is liable on conviction or indictment to imprisonment for 10 years if the person colludes with an external force to knowingly incite any of the personnel of a CA office in Hong Kong to abandon the duties and abandon the allegiance to China. Question? No. Clause 21. Possession of documents or articles of incitement nature with intent to commit specified offence. 1. A person commits an offence and is liable on conviction or indictment to imprisonment for 3 years if the person, with intent to commit a specified offence, possesses a document or other article of such a nature that the distribution of a document or article of that nature to a relevant officer would constitute the specified offence. In this section, specified offence means an offence under section 17, 19, or 20. Relevant officer means A. In relation to an offence under section 17, a member of a Chinese armed force. B. In relation to an offence under section 19, a public officer within the meaning of that section. C. In relation to an offence under section 20, any of the personnel of a CA office in Hong Kong within the meaning of that section. Question time. Mr. Tong Li-Jie. Thank you, Chairman. I would like to understand that under the clause documents or other article, I think items and articles in electronic form are also covered. So if a person merely possesses these articles without distributing them, would the person be caught? What about possession of inciting articles? The provision specifies 2 elements: possession and also the distribution of the documents or article of that nature to a relevant officer. Only then would it constitute the specified offence. So there are 2 steps. First, possession, and second, distribution of the article. I invite Mr. Leung to supplement. By way of clarification, Chairman, Clause 21, the offence does not require proven distribution. Now, the act is first possession of the document or other article of such a nature. The second half of the clause means that if such articles or documents are distributed, it would constitute incitement to disaffection. So the mens rea pertains to the first sentence. A person commits an offense and is liable on conviction, and so on, with intent to commit a specified offense. So if there is an intention to commit the incitement to affection and you possess the article, you're already guilty. We don't have to prove that someone has distributed the article or documents. So what about those documents in electronic form? And about your previous answer, I need to clarify it. Possession with an intent to commit the specified offense, meaning these articles or leaflets or documents. If someone receives these articles and out of curiosity, the person reads it but forgot to dispense of it, then the person may be caught by the law. There is a similar element in clause 23. Simply possessing these documents would be in breach of the law. Which official? Mr. Leung? Once again, I stress the term with intent to commit a specified offense. If someone receives such a document, then it would not constitute the offense in clause 21. Dr. Kennedy Wong.
Chairman, further question on possession. It's common knowledge that very often we receive messages on our mobile phone from somebody unknown. If I forget to wipe it clean and if it's stored in my mobile phone, would it count as possession? Let me take this question. It is important to consider intention. Now, someone mentioned receiving an email from somebody anonymous, and if I don't open it and I don't have intention, then it's all right. The word intent or with intent are important. Possession of documents or articles of such a nature, so on and so forth, it's not hard to understand what possession of documents or articles, possession of documents mean. But what about articles? How can you tell whether it is an article of incitement nature? Do we need to give a clear definition? Article here refers to something other than a document. It could be, say, a sculpture or other articles. But what is important is that if this article is distributed to a relevant officer, it would constitute the specified offense. So there is an intention of incitement. Or some articles could be interpreted in different ways. So how do you make sure that how do you make sure that people will not be inadvertently caught by the law? Well, I don't think this will happen because, as I explained, we need to consider the intention is for the prosecution to prove beyond reasonable doubt the intention. That is to say, distributing this document or article will constitute an offense. Legal advisor. I have a question on Division 3, the offenses of incitement to the mutiny, etc. There is a similar offence in the provisions of the current ordinance that will be repealed. In Section 7, subsection 6 of Cap 200 Crimes Ordinance, if necessary, the Secretary for Justice will seek consent before proceeding with prosecution. And then Division 3, be it Clause 19 all the way to Clause 21, there is no such requirement of seeking approval. So the question to be asked is whether there is no requirement for the SJ's consent to initiate prosecution. There will be an umbrella provision applying to all the NS offences, echoing Article 41 of the HKNSL. A written consent from the SJ should be sought before initiating prosecution. So there is no specific provision for this offence. If there are no other questions, let's go to Division 4, Clause 22. Seditious intention. Subclause 1. For the purposes of this division, a person does an act with a seditious intention if the person does the act with one or more of the intentions specified in subsection 2, and an act, word, or publication is an act, word, or publication that has a seditious intention if the act, word, or publication has one or more of the intentions specified in subsection 2, and then subsection 2, the intentions are as follows. A, an intention to bring a Chinese citizen, Hong Kong permanent resident, or a person in the HKSAR into hatred, contempt, or disaffection against the following system or institution. 1. The fundamental system of the state established by the Constitution of the People's Republic of China. 2. A state institution under the Constitution of the People's Republic of China. Or 3. The following offices of the central authorities in Hong Kong. A. The liaison office of the CPG in the HKSAR. B. The offence for safeguarding national security of the CPG in the Hong Kong SAR. C. The office of the Commissioner of the Ministry of Foreign Affairs of the PRC in HKSAR. Or D. The Hong Kong garrison of the Chinese People's Liberation Army. B. An intention to bring a Chinese citizen, Hong Kong permanent resident, or a person in the HKSAR into hatred, contempt, or disaffection against the constitutional order, executive, legislative, or judicial authority of the HKSAR. C. An intention to incite any person to attempt to procure the alteration otherwise by lawful means of 1. Any matter established in accordance with the law by the central authorities in relation to the HKSAR. 2. Any matter established in accordance with the law in the Hong Kong SAR. An intention to cause hatred, enmity amongst different classes of residents of the HSAR or amongst residents of different regions of China. E. An intention to incite any other person to do a violent act. And then F. An intention to incite any person to do an act that does not comply with the law of Hong Kong or does not obey with an order issued under the law of Hong Kong. 3. However, if a person doesn't act only with any of the intentions specified in subsection 4, the act is not done with a seditious intention. And B. If any act, word, or publication only has any of the intentions specified in subsection 4, the act, word, or publication is not an act, word, or publication that has a seditious intention. The intentions are set out in subsection 4A. An intention to give an opinion on the system or constitutional order mentioned in subsection 2A or B with a view to improving the system or constitutional order. B. An intention to point out an issue on a matter in respect of an institution or authority mentioned in subsection 2A or B with a view to giving an opinion on the improvement of the matter. And C. An intention to persuade any person to attempt to procure the operation by lawful means of 1. Any matter established in accordance with the law by central authorities in relation to the HSAR. 2. Any matter established in accordance with the law in the Hong Kong SAR. D. An intention to point out the hatred and enmity amongst different classes of residents of the HKSAR or amongst residents of different regions of China is produced, or that there is a tendency for such hatred or enmity to be produced with a view to removing the hatred and enmity. I think we will pause here We will move on to the second item now, and that is AOB, nothing under AOB. I'd like to inform members that at 2:30 this afternoon, we will hold the 5th meeting. So do come back. Please refer to the notice. If there is nothing under AOB, then the meeting is adjourned. I'll see you at 2:30.